think one of the things that needs to be, made perfectly clear in this case is that Jake did not get involved in the case until later on after the MSA was signed. And I think that's been part of the problem.
Is this the person that is ordered away from the children?
Yes, Your Honor.
Okay. Just so that the parties understand, I'm catching up a little bit as far as reading records of previous hearings as well. So but I still do take full responsibility, and the way that I roll is that kids are entitled to visitation with both of their parents, regardless of what is going on in the wide world.
I get you.
World Wide Web.
Your Honor,
or the dark web.
Sure. It might be the dark web. Who knows? The question I think what my client wants to make perfectly clear to the court is that if the court is inclined to keep the children away from him, he would request that the children be in a neutral location, so there's not any kind of attempt to coach the kids in any manner.
If the court is not inclined, for the record, the court is not inclined to keep the children away from either of their parents. Okay. So are the attorneys feeling confident that they can reach a better agreement? School is online, perhaps, right now? Is that true?
Yes, Your Honor. May I respond briefly, Your Honor? Because I know there's been a lot of discussion. Our stance at this time is that the children are in danger in Dad's care. I believe that was the position of, and if you look at her motion, and if you hear from CPS today, they have serious concerns about Father, not just the issues that he violated the first 2 court orders of the court-ordered exchange, but that he's causing scenes at the exchanges that's causing emotional, long-term harm to the children. The child, Sophie, is now in care with a counselor that was been court-appointed, that was agreed upon. Also, there's psych evals for both parents by Dr. Blake Mitchell that's been agreed upon, also by his former counsel. Father has not complied with anything, to my understanding, has not paid the amicus fees, has not complied. So our position is that we believe that the children would be endangered by interacting with Father. Father has made previous threats to take them out of the country, that he's going to hide them. He's posted this on Facebook. I believe that, Your Honor, if you hear some testimony, that you'll be able to render a decision regarding that.
Okay, so the concerns of CPS are that Dad has threatened to take the children out of the country and that the exchange went badly.
And that Dad has some possible mental illness issues. There was a psych eval done in 2017 that addressed some of those issues. I believe Ms. Deal would be able to testify that she was at Mr. Long's residence the forensic outcry or lack of outcry, the kids were forensically interviewed and gave statements that Dad has them memorizing license plates, that he has guns all over his house, protective vests, gas masks, believing that the children are in danger. Something along those lines. I don't want to speak on behalf of CPS. I'll let them speak for themselves. They're here today, Your Honor.
Your Honor, if I could respond to that, there's a lot of rhetoric that's being traversed about at this point, and I think the TRO that you signed several days ago basically was the affidavit that was attached that you reviewed prior to signing the TRO is defective. I don't think it outlines the emergency nature of what you signed, and I think that the only thing, as long as I can get clarity on what's before the court and it's the TRO, I think that that affidavit does not rise to the level that gives the court the ability to sign a restraining order precluding Dad from getting any access at all. And I have to say, Ms. Shamet has done a remarkable job at hiding really what's really going on in this case. And I don't mean that rudely. I just mean there has been so many things that have been going on at this point between the time that you signed that TRO and currently. And I don't know if you've had the opportunity to look at the video that of the exchange, I know, I don't believe that it's been put into evidence, but I do believe that that's something that's super relevant at this point. I think the child is making outcries. I think that there is clearly an issue with regard to Jake. I think there's clearly an issue, at least with regard to the child's representation, that mom is participatory in this, which is really this allegation, but it's something that's coming from the child. I do not believe at this point that this child should be in the care of mom, and that's just going to be my position and my client's position. But I think if you really look at the evidence, clearly there are issues, serious issues. And if you believe a 9-year-old child, as I think you should, at least until you get some serious mental health professionals involved in this case, that I do not believe have really been participatory in the proceeding at this point, and I do believe it's necessary that we have that. I can't even imagine that this child would be returned to mom. So
do we know, Ms. Graham, whether FESS is ready to support dad and mom with the kids?
I don't know at this point. I do know that a number of them were undetermined, and I can't answer that.
So what I'm referring to is the mental health part. I don't know how the parties are going to be able to sustain. Like, I know that one of the children is in care with a counselor that both parties agreed to. That is, both mom and dad agreed to that appointment. I know that psychological evaluations have been ordered with Dr. Blake Mitchell, and those were also agreed to by both mom and dad. So I don't know how hard it is to do telehealth for that, or whether or not they have to come to the offices. So there are issues for sure. This family, my understanding is this family has had perhaps some previous CPS involvement. I don't know what that amounted to. I have not had the evidence admitted before me. Now, I do not know whether or not, I'm trying to sort through, I do not know whether or not that was when this family was intact, or whether this family was already split up, or exactly what that history is. But I intend to take up all those issues at our future hearing.
Your Honor, Judge Lori Hockett did see those videos. There were 3 videos. The one I believe Ms. Graham is referring to for the internet has been edited. The full video has been seen by Judge Hockett along with 3 other videos. And in addition to that, the amicus attorney has viewed them, and the CPS worker, Chelsea Deal, viewed them. And Your Honor, I would urge the court to not modify the orders at this time until Your Honor is able to have the hearing and see all of the evidence before the court. I think it would be very easy to go along with what Ms. Graham said and with what social media has seen, which is a small portion of the overall big picture of all of the issues that are involved in this case, the long history of CPS issues with these parties. It's not just a 2-second simple matter, unfortunately.
And as an officer of the court, you are conceding that both of these parties, both your client and father, have had CPS involvement before they ever arrived in my county?
Yes, Your Honor.
Okay.
And CPS is here and can speak to that as well.
That is not going to happen because we agree that this is going to be continued.
Understood.
All right, so father's attorneys, you all received that I have ordered a Zoom visit daily with the child, so that the standard possession order can be in part ordered. How are we going to have that? Do you all have suggested supervisors for the, I don't agree that because an exchange goes poorly and because there's a lot of videoing and posting those videos to the internet would probably not be anyone's natural inclination of their child. However, in this case, everybody was under a great deal of stress and children's safety was at issue for a variety of reasons, not just the fact that she had made an allegation. So I'm not judging any of that right now, but what I am saying is that with the orders that I have in place, that is, I've ordered no party to disparage the other party at any visit, which I've ordered Zoom visits for the time being. And I have ordered that no party upload a child on a video so that the internet can, and I have clarified that, I guess Mr. Long has a question.
No, I don't think he does have a question. I'll visit with him when he does.
Okay, do you want a breakout room?
Would you mind?
Not at all.
Thank you so much.
We are back on the record and the court is about to announce my memorandum order from last evening, yesterday afternoon, so that we can have the further clarification and discuss the issue of visitation in between today's date and the date of our continuance. All right, memorandum order. The court makes the following findings. The court issues the following temporary orders. The court finds that the children had been with their father for extended summer visitation prior to the first TRO granted by this court. The court now orders that father receive Zoom visits with his children, 15 to 20 minutes each child, or an hour with all three kids, every day at a time arranged by the parties through their lawyers after work so that no conflict with either parent's schedule occurs. Both parents are ordered not to discuss the litigation or disparage the other parent during these visits. These visits are found to be in the best interest of these children. Number 2, the verbal order on August 31st, 2020, which temporarily sealed the case, open parens, sealing, / open quote, gag, close quote, order, close paren, was vacated and withdrawn on September 1st, 2020. All parties were emailed this order on September 1st, 2003. The temporary orders heard on August 20th, 2020, enjoined, open paren, prohibited, close paren, Jacob Bellington, to be in the presence of the children subject of this suit. To be clear, the court now orders absolutely no contact with mother's boyfriend, Jacob Bellington, or any other unrelated male to be around these children. Number 4, both parties agreed on record during the August 31st, 2020 hearing to remove all video, audio, and name identification containing the children subject of this suit from all platforms and social media. The court order on August 31st, 2020 did not seek to shut down, control, manage, or seize any account, including GoFundMe, Facebook groups, Facebook, Twitter, TikTok, YouTube, or any other platform. The court order solely sought to protect the children's identity via audio / video. 5, the court is presently reviewing all previous records from prior hearings, all pleadings and briefings, as well as the transferred records from Comal County, Texas, cause number C2015-0238D, styled in the matter of the marriage of Michael Long and Kelly Long, and in the interest of SAL, JLL, and LAL children. 6, all email correspondence relating to pending cases will be filed with the district clerk for inclusion in the record of the case. Any communication to the court or staff via email must comply with Rules 21 and 21A, Texas Rules of Civil Procedure, and to do so by the fastest means available to the other affected parties or counsel. The provisions of Canon 3B8 of the Code of Judicial Conduct should be carefully reviewed before any person connected with a case attempts any communication with the judge or court personnel. 7, this case has been set for trial or a trial before the court on November 4th and November 5th, 2020 at 9 a.m. Any other matters in the last TRO will be taken up at the hearing as scheduled on these matters on Thursday, September 3rd, 2020. Signed this second day of September 2020 by me. So, Ms. Graham and Ms. Lishman and Ms. Shemish, we have an SPO based on the last order of parents living over 100 miles apart. That is the order that the court is legally permitted to adhere to. That is the last order in place with regard to visitation with the children. Tell me the reasons, if you will, for not adhering to that schedule with proper restrictions in place. We have restrictions in place from the previous judge where boyfriend was alleged perpetrator was not allowed around the children. We had also restrictions regarding that first visit with mom as ordered by the previous judge sitting in visitation for me, that I believe that portion of visitation was supervised by the grandmother. And then we are back to no orders regarding visitation except for the original order in place in the final decree, which was, I guess, not modified in the motion to modify, correct?
Correct, Your Honor.
Yes, that's my understanding, yes.
All right. So to the allegations of whether or not the exchange will go poorly under proper orders of this court, I believe those can be controlled by the declaration of the attorneys as agents for father, that those concerns will not occur at any future exchanges on either side. Let it be known that this judge has not actually had in evidence before me the 3 videos that were referenced by Ms. Graham. So that is what I'm assuming there will be additional pleadings filed so that we can all be brought up to speed as to what is in the best interest of these children. I will, however, review the evidence, and it was already given to me by the court reporter that was substituting in. So I will review that before our extension of the current TRO, which is currently modified by my yesterday afternoon rulings.
Oh, Your Honor, I don't mean to interrupt, but my client has a number of questions. One of them is how long are we going to be before we actually have an evidentiary hearing on the case? That's the first question. He is not sure where the children are at this point. He'd like to kind of know where they are. That's the second one. He's concerned about whether or not the minor child of Jake and Kelly is having visitation and whether the kids are present during that visitation. Those are 3 concerns that he wanted to address. I think that he wanted to address to the court previously before we had our breakout sessions.
Okay, so there have been safety issues regarding the location of the parents that require that really both parents' locations not be shared. However, I am 100% certain that this exchange of visitation will go down without any form of all the things that took place, and that the children will be returned in conjunction with the order that these parties agreed to back in 2017 and was signed in 2020. So July of 2020, a lot was different. And, but what I'm permitted to, I don't even actually know the answers to some of these questions. I do believe that the attorneys should review and go over these things by attorney's eyes only, because my order will be complied with. That is, these children will not be around Mr. Bellington at all, period. The other case regarding another child not the subject of this suit, as the lawyers well know, I am not entitled or privy to that information. So all three of you as officers of the court, and with your duty of honor and truth to the tribunal, know that that answer is not in the possession of this court. So all three of you need to discuss these matters between and among yourselves, but until I have a violation of my order with regard to either of these threats, this court is not even entitled to that information, as you know, Ms. Graham.
Your Honor, if I may get some clarification from the court at this time.
Go ahead.
Judge Hockett entered some temporary orders with injunctions regarding father not being allowed to take the children to any medical professionals, as he had taken the daughter Sophie to over 7 medical professionals while she was in his possession, which I believe you'll hear more testimony and evidence at the next hearing. But will those injunctions still remain in place?
Gosh.
And also the child was taken to numerous interviews regarding this, and the judge also ordered that only the Child Advocacy Center of Collin County would be able to do one other forensic interview, and that dad was prohibited from taking the child to be interviewed by anyone else regarding this.
Can I respond to that, Your Honor?
Yes.
Okay, so the child was taken to 3 different places. Particularly, the reason that she was taken to 3 different places was because the child refused to be seen by a male physician. So on June 28th, the child was taken to Oak Run Medical Center. She had what they called
Ms. Graham, let me back you up just because I really do want my own chronology of events. So on June 28th.
Sure. The child was taken to Oak Run, Texas Med Clinic in New Braunfels. She had bacteria
from New Braunfels.
Excuse me?
Why would anyone move from New Braunfels, Texas?
I know, isn't that the truth?
What? Okay.
So the child was taken, she had bacteria in her urine, so they took her to Oak Run. She continued to have issues. She was taken on July the 2nd to a place called Little Spurs. They gave her a round of antibiotics for her vaginitis and what they considered to be a yeast infection. She went on visitation with mom on the 10th, 11th, and 12th of July. She came back from mom's visitation on July the 16th, or from mom's visitation on the 12th, and she was taken back to Little Spurs on the 16th. On the 16th, she continued to have pain, or she continued to have issues where she couldn't even sit down. And they gave her another round of antibiotics, I believe, and then on the 25th, she was taken to Dell Children's Hospital, or Dell Children's facility. So she was taken to 3 different places: Little Spurs, Oak Run, and Dell Children's. And I want the court to be aware that the reason that that happened was that the child refused to be seen by a male physician.
Thank you.
Sure.
Sorry, Your Honor. This is where we'll probably need a very extensive hearing. Dr. Morgan, who was one of the doctors that Dad took her to, gave very interesting testimony regarding the threats from the father that she felt. And this is where I feel like, Your Honor, we really need a long evidentiary hearing to hear all of these issues.
Agreed.
I agree with that as well.
You will absolutely get that. I don't know exactly what the date will be. I'm going to have to consult my calendar because this really does need some time.
There were more places. In addition, there was an urgent care in Temple, Texas, that Michael Long's wife took the child to. And I believe Rachel Lee in her motion also addressed that, and that's where we would be able to have some testimony with regards to that.
Do you have the date on that urgent care in Temple so that we all have that as well? Mr. Long is wanting to answer, but that's okay.
No, Ms. Shemesh, do you have the date?
I'm looking right now.
Okay.
Because my information is that Dr. Morgan never had any interaction with Mr. Long at all. So, I mean, we can have this at a hearing. I'm sure that we'll have to get out the testimony and before the court, obviously. But
I'm just
Your
asking
Honor,
for the date. I'm just asking for the date of urgent care.
can Mr. Long respond to that, Your Honor?
Mr. Long, you can respond through your lawyer, so text her, or I just think it's best not to take any evidence at all because no one is sworn.
I completely agree with that, Judge. Thank you.
It's hard to text and be on a Zoom hearing, so we'll just wait for Ms. Shemesh because I've tried that.
Sorry. It's an extensive case, Your Honor. I'm digging through right now.
Of course.
Your Honor, as long as we're waiting for that date and nobody has come up with the date, can we get some inclination as to when the court's inclined to have this additional temporary orders hearing?
No, we can't do that because I'll have to switch to my calendar, which might knock us off soon.
Okay, no, that's fine. I get it. I get it. I appreciate it.
The logistics of this whole pandemic have been wild for me.
I know.
Yeah.
I get it.
Now that the whole world knows my age, I'm old and I have to really come up with some serious technology.
Right?
Your Honor, I'm still looking, but if I recall correctly, it was August 18th.
All right. So is that the other one that you wanted to add, Ms. Shemesh? Is that?
Yes, Your Honor. And I believe that there were more, and CPS would be able to testify with regards to that, and along with my client.
Okay. So here's the thing. It is not in any child's best interest not to be taken to the doctor if they should fall ill during a visit. So the injunction with respect to father taking any parent, mother or father, taking the child to a doctor, to me is fraught with danger. So what I will say, though, is obviously, it'll be more obvious with the second. The second injunction was related to not taking children for additional forensic style interviews. There are actually law enforcement officers that give talks to judges and they say it's not good for their case. That is, it's not, doesn't make the prosecution any easier by taking a child to multiple places. Although I understand that if you as a parent felt your child wasn't being heard, then you would be inclined to do that. I don't see that as nefarious, but I will say that injunction will remain in place. So no additional forensic style interviews other than the Collin County CAC.
Can I get a clarification on that, Judge? Because it's my understanding that the amicus attorney did herself engage in what would be kind of a forensic interview of this child. And if we appoint a new amicus, that would lead to another interview. I'm just trying to get a little clarification on the amicus. If you appoint somebody else, are they permitted to talk to the child and essentially conduct their own forensic interview? And if that's the case, I would have to ask for somebody who's actually qualified to be able to do that, who has the training and the experience and the credentials to know how to do that in an appropriate way.
Right. I can't speak to any of that yet. I have not had that in my, any evidentiary hearing as far as what took place prior. I have not appointed a new amicus, and I don't know at this point. I mean, the parties' resources are going to be spent on getting psychological evaluations for the parents, as well as counseling for all 3 children post haste. So these therapeutic interventions must be done and must be done quickly. We need healthy, emotional folks to take care of their children and co-parent them until the age of 18. So keeping children safe is not just whether or not one person or the other is guilty of a crime. There are so many other layers of collateral type safety that have to be addressed by both parents going forward, and the trauma of just the court case that the children will necessarily be suffering from. So let it be known that the resources of this family should be focused not first on a court battle, but first and foremost on every person in this family that is not together anymore getting the help they need. But first and foremost, all 3 children are suffering. No question about that. And I will, I guess what we'll have to do is get with the court's coordinator. Again, I will live stream on YouTube every future hearing and interaction. This is the first weekend of the month, and it seems to be an appropriate weekend for an exchange. And again, I want strict orders on both parents that there will be no interactions of disparagement, no interactions of name calling or any type of anything between these 2. Obviously, they're involved in a very, what can I say, acrimonious relationship at this point. But that does not have to, that happens all the time. In a lot of family law cases, people do not like each other, but they do not divorce their children. So both parents at this exchange need to be with smiles on their faces, not having, stress-related reactions in front of their children. It's, it's about maturity. It's about keeping your own emotions in check so that the children are not disturbed. No matter how much you may dislike each other at this point, it really doesn't matter. You don't divorce your children, and you have to co-parent for the rest of their lives. So as long as both sides are keeping their kids safe, both emotionally and physically, with proper restrictions in place, there is no need to keep either parent from their children, and more importantly, these children from their parents. It's their rights we're talking about. It's these 3 children's rights we're talking about here. This weekend is a long weekend, so I'm going to order the extra day be Dad's extra day. So the return of the children with the Waco in mind should be on the, I don't know actually my dates right now. I believe the 7th is the day off from school.
That's correct.
Is that right, guys?
Yes.
All right. So would that be in keeping with the other order? I have no idea what it said. We would be a Friday at noon exchange. Is that what's been happening? No? Okay. We can't get to Waco by noon. Okay. So what time was the typical?
I believe it was 5 p.m. Fridays at 5 to Sundays at 5, but we're going to.
Your Honor, in terms of the typical order, I think that's where we absolutely need a hearing. He wasn't adhering to that typical order where he was getting 1 weekend every month. And so that's where I urge the court that the court needs to hear testimony with regards to everything.
Your Honor, I think that Monday at 5 o'clock would be appropriate. This father needs to have some eyes on these children, considering what's happened in the last 10 days. I can't imagine not being able to see the kids or talk to the kids or have visitation with the kids at this point, given all of what has been happening and transpiring in this case. I do agree with Mr. Mesh that we should have a hearing. I do agree with that, and I think we should have a full evidentiary hearing. Do I
Agreed.
believe?
Okay, thank you. And Ms. Graham, I do want to correct your slight misunderstanding because it preceded your presence in the case.
Sure.
The original order was signed by me, and it was giving Dad full custody and Mom 0. So,
Okay, well, thank you for that correction, Your Honor.
let's be clear. Let's be clear.
Thank you for that.
All right, thank you. And prior to that, my understanding was that the parties were giving this school year notice of which weekend it would be. So that seems to me to be very loose as to be not even enforceable. So that needs to change for sure going forward. And that was agreed to in the MSA and put into a final order 3 years later in 2020. So absolutely, we'll do a full evidentiary hearing. Both sides need to get their pleading straightened out too.
Your Honor, if I may, just for the record, I'd like to state my objection to modification of any order without a hearing.
Yes, go ahead.
Thank you. I just wanted to let the record know that I would object to Your Honor modifying any order at this time without actually having a hearing on the issue.
And what order are you specifically referring to?
To the previous order of the party, Your Honor, from July of 2020, in which that order specifically states that father would have to have given notice for the dates that he would have had possession of the children. My interpretation, I believe opposing counsel's interpretation too, as they stated earlier, was that father would not be having any possession until the 16th. My understanding is that, Your Honor, we could reset this case because the other side, Michael's side, has requested a continuance to allow them to catch up with everything and possibly to allow the court or anybody else ability to catch up with that. Reset it for a date soon enough to where we're not denying father and the children, being in danger, but father would be able to actually view the children, as Your Honor already put in her memorandum, by Zoom.
Okay, thank you. The court still modifies the extent of modification of the 2020 July 7 order. The extent of the modification is the lack of notice to Mom, and that was to be had prior to the school year, which was, I guess, August 20th. That is the only modification of this court. What was the date of school? What was the date of notice that was supposed to be given?
2 weeks prior to the start of school, Your Honor.
Okay, so early August, notification was not given by Mr. Long, which his lawyers have conceded that he did not give that notice in early August. He had possession of the children at that time under a TRO. So the court is modifying the lack of notice only and adhering to the SPO of families living over 100 miles apart. We are now in recess. My court and I will discuss the future hearing. You attorneys will discuss the exchange place and keep that confidential. The hearing itself will be live streamed, and therefore I will let the parties know by the usual methods.